Now concede they can't rely on a statistical theory of injury like the lower courts did. Instead, they have to identify a specific doctor who faces imminent harm. But their theories rest on a long chain of remote contingencies. Only an exceptionally small number of women suffer the kind of serious complications that could trigger any need for emergency treatment. It's speculative that any of those women would seek care from the two specific doctors who asserted conscience injuries. And even if that happened, federal conscience protections would guard against the injury the doctors face. And there's no basis to conclude that any of that would be traceable to the incremental changes that FDA made in 2016 and 2021, as opposed to the availability of mifepristone in general. Respondents' theories are too attenuated as a matter of law. The court should say so and put an end to this case. If the court reaches the merits, FDA's actions were lawful. The agency relied on dozens of studies involving tens of thousands of women. Respondents don't identify any evidence that the agency overlooked. They just disagree with the agency's analysis of the data before it, but that doesn't provide a license to authorize judicial second-guessing of the agency's expert judgments. Finally, on remedy. The relief entered below would severely disrupt the federal system for developing and approving drugs, harming the agency and the pharmaceutical industry. It would also inflict grave harm on women across the nation. Rolling back FDA's changes would unnecessarily restrict access to mifepristone with no safety justification. Some women could be forced to undergo more invasive surgical abortions. Others might not be able to access the drug at all. And all of this would happen at the request of plaintiffs who have no certain injury of their own. The court should reject that profoundly inequitable result. I welcome the court's questions.
General, if we agree with you on standing, could you give us an example of who would have standing to challenge these FDA actions?
As a general matter, we've seen lawsuits in the past that are brought by, for example, prescribing physicians or patients who want greater access to a drug. Sometimes we've seen theories of competitor standing, where a competing drug manufacturer might sue and claim that FDA's approval of a drug creates a competitive harm or injury in that sense. Justice Thomas, I think that if the question is whether there would be individuals who generally oppose abortion who would have standing and want to challenge FDA's actions, the answer to that is no. But the reason is because those people aren't regulated in any relevant way under FDA's decisions here. Take these respondent doctors. They don't prescribe mifepristone. They don't take mifepristone, obviously. FDA is not requiring them to do or refrain from doing anything. They aren't required to treat women who take mifepristone. FDA is not directing the women who take the drug to go seek out care from these specific doctors. And so they stand at a far distance from the upstream regulatory action they're challenging. And the court has said in many cases that in a situation like that, when you are not the direct object of the agency's regulation, it can be substantially more difficult to establish standing.
But isn't that sort of a criticism of some of our associational standing cases and organizational standing cases?
I don't think it is for a couple of different reasons. With respect to associational standing, this court has said time and again that the association needs to identify a specific member who is suffering a concrete harm, a cognizable injury that's non-speculative. And I don't take respondents now to take issue with that fact. They're agreeing that it would be necessary to come forward and identify a specific doctor. The problem with their associational standing theories is that they rest on this chain of remote possibilities, so many different steps in the process that would have to occur, each one layering one speculative remote odds of a chance of injury on top of another to get to the ultimate harm they're claiming on behalf of these doctors.
Well, you emphasize the remote nature of the injury, the small number of adverse effects, the likelihood that the patients will go to the emergency room, and so on. Is there a number at which your argument would change? The significant number of consequences, a higher likelihood of an emergency room visit, doctors who spend more time in the emergency room. At some point, does this analysis lead to the other result?
It's hard for me to imagine that it could, and there are a couple of different reasons for that. I take the point that you might pick out different links in the chain and suggest that there are ways to wildly depart from the facts here and suggest maybe as a statistical matter, one or two of those events could be probabilistically more likely to occur. But we have an objection here to the underlying theory as a legal matter because it rests on so many different things that would have to happen one on top of another and that turn on independent decisions made by third parties who are strangers to this litigation, who are not part of the suit. So we think that brings the case within those like Clapper or Summers, where this court has recognized that when the theory of injury really turns on so many different intervening events separated by independent decisions, it can mean that there is just an insurmountable hurdle to establishing standing.
Could you provide a more specific answer to the first question that Justice Thomas asked you? Is there anybody who could challenge in court the lawfulness of what the FDA did here?
In this particular case, I think the answer is no.
Well, that wasn't my question. Is there anybody who can do that? Let's start with the states that intervened below. Will you say in that litigation, fine, you can challenge it, and let's get to the merits of this issue, the lawfulness of what the FDA did?
No, we think the states lack standing. They're asserting indirect injuries that would, if it provided a basis for standing, mean that states could always sue the federal government. And the court cautioned against that result in United States versus Texas, footnote 3 of that decision.
Okay. How about a doctor who opposes abortion? So she's on duty in an emergency room when a woman comes in with complications from having taken mifepristone, and the doctor's the only one there on duty who can attend to this woman's problem, and as a result, in order to save her life, the doctor has to abort a viable fetus. Now, would that doctor then have standing to seek injunctive relief, or would you say that's too speculative? This was like being struck by lightning, and there's no, it's not sufficiently likely that this is going to happen to this doctor again.
We would agree that that would represent past harm, so we're not disputing that that kind of conscience violation, providing care in violation of one's conscience, would be cognizable. But yes, we think that that situation has never come to pass. Respondents haven't identified any incident in more than 20 years that mifepristone has been available on the market that resembles that kind of hypothetical situation. And so, yes, our view would be it's unduly speculative. And you have to think about all of the events that would have to transpire to get to that moment in time.
Sure, no, I understand the argument. Now, how about a woman who suffers adverse consequences from having taken mifepristone? Would she be able to sue for damages, or you would say that's barred by sovereign immunity?
I expect that we would have sovereign immunity arguments in that kind of case. I recognize that with respect to traceability, that's a harder argument for us.
Okay. Is there anybody who can sue and get a judicial ruling on whether what FDA did was lawful? And maybe what they did was perfectly lawful. But shouldn't somebody be able to challenge that in court? Who, in your view? Who would have standing to bring that suit?
I think that with respect to these regulatory changes, it's hard to identify anyone who would have standing to sue, but the court has said time and again that the fact that no one would have standing doesn't provide a basis to depart from Article 3 principles. It said that in Raines, in Richardson, in Valley Ford, and in Clapper, and so I think it's clear that even if there is no alternative person here who could sue, that doesn't mean that the court should dispense with the indispensable requirements of Article 3.
Okay, I understand that, and Article 3 is important. So your argument is that it doesn't matter if FDA flagrantly violated the law, didn't do what it should have done, endangered the health of women. It's just too bad nobody can sue in court.
Certainly we think that
there's no remedy. The American people have no remedy for that.
Well, I think that it would be wrong to suggest that if FDA had made a mistake and a drug were actually producing safety consequences, that there would be nothing to be done. I don't think that these respondents could invoke Article 3 jurisdiction to have the court step in, but FDA takes very seriously its responsibility to ensure the safety of drugs. It conducts ongoing surveillance and can make adjustments to the regulatory regime if safety situations emerge. The drug sponsors themselves remain responsible at all times. We have a tort system in this country, and that can help ensure that if there are safety problems that come to pass, the sponsors will take action in reaction to that. So if the premise here is that unsafe drugs could somehow remain on the market, I think that that's incorrect.
I mean, so your argument here is, and as I said, I have great respect for Article 3. We all do. We have to comply with it. But your argument here is that even if the FDA acted unlawfully, nobody can challenge that in court. And that's basically the argument you made last week, right? In the Murphy case, we shouldn't get to the question whether the White House and others violated the right to freedom of speech. We should just say, well, these plaintiffs can't bring suit, right?
We are looking at the specific respondents in this case and their theories of standing. We don't think they come within 100 miles of the kind of circumstances this court has previously identified of non-speculative harm that can create the kind of cognizable injury for forward-looking relief.
I'm assuming that if there were if this had been unsafe in a grossly visible way, 40% more increased hospitalizations, that some doctor who was prescribing it would have challenged the lack of an in-person.
Well, no doctor is required, Justice Sotomayor, to dispense others.
No, but if a doctor who wants to, just like a doctor who wants to do abortion, we have said if there's regulations that stop them from doing it, I guess that doctor could come in and say, this is unsafe. I can't, by not having people visit me beforehand, we're not warning them, et cetera, et cetera.
Certainly, I think if those kinds of distinct safety concerns emerge, there would be steps taken at the agency level. There's nothing like that here. There's no contrary evidence to suggest it.
I'm pondering a hypothetical.
But I do want to be clear that FDA's regulations here don't require doctors to not grant an in-person visit if they think that that is the best way to provide a standard of care here. So they are not directly required to dispense mifepristone through any particular arrangement.
Counsel, can I ask you a question about the conscience injury? So that's one of the roadblocks you identify in the speculative chain, because you say a doctor could invoke federal conscience protections to refuse to complete an abortion that was when the embryo or fetus was still alive. So I just want to be clear, the federal government's position is that their doctor would have conscience objections. I'm thinking about the EMTALA litigation, and the Fifth Circuit criticized the government's inconsistent positions. But it is your position that such doctors would have recourse to the conscience protections of federal law?
Yes, absolutely. And let me be clear about this, because I think the Fifth Circuit did fundamentally misunderstand our arguments, and respondents have repeated that misunderstanding here. The federal government has never taken the position that EMTALA would override an individual doctor's conscience objections. We said exactly the opposite. If you go and look at our Fifth Circuit reply brief in the Texas litigation, we disclaimed that understanding of EMTALA and made clear that we understand the conscience protections to continue to apply and shield the doctor who doesn't want to provide care in violation of those protections.
Would that be true in a healthcare desert as well?
Yes. So we don't think that EMTALA would override conscience protections for the individual doctor. It, of course, imposes obligations on hospitals, and hospitals have all kinds of plans in place to address these types of contingencies. They have staffing plans. I understand as a matter of best practices, they often ask for doctors to articulate their conscience objections in advance so they can take account of that in staffing. They have cross-staffing agreements with other hospitals. And in the government's experience enforcing EMTALA, this is almost 4 decades of experience, we are not aware of any situation where there has been that kind of direct conflict between EMTALA and conscience protection.
Okay, and just one last question. This is about the association standing. So its own standing in its own right. I'm talking about not its standing that is based on an injury to one of its members. So the injuries that the association is arguing sound in the Havens Realty associational standing, and they're the kinds of allegations we see by immigration advocacy groups. Diversion of resources, increased expenses that result from the complications of having to address and explain the new changes. And I'm not talking about the expenses of filing the petition. That's not what I'm talking about. Let's just talk about the diversion of resources. Can you distinguish that from Havens Realty?
Yes. So I think Havens itself was trying to distinguish between 2 types of potential organizational injuries. And what Havens said is that in that case, the organization had come forward with direct and concrete demonstrable injury to itself. And there, the organization had a contract to provide low-income housing or a search to secure it for clients, and the racial steering practices directly interfered with that, made it more difficult for the organization to carry out its contractual obligations. But Havens itself said that it was not blessing a theory of standing that would allow an organization to assert a setback to its abstract social interests. So I think that reflects the court trying to distinguish between more concrete, direct, demonstrable harms on the one hand and that kind of abstract setback on the other hand. And I recognize, and your question touches on it, Justice Barrett, that some lower courts in particular have seemed to read Havens to endorse far broader theories of standing, including in the immigration context. The government has been routinely resisting standing because we think that that would essentially essentially mean that any advocacy organization could say it opposes what the federal government is doing and so therefore has to devote resources to that opposition. If that were enough, then every organization would have standing and it would be a vast expansion of ordinary Article 3 principles. So we would welcome an eventual clarification from this court on organizational standing, but here I think that the organization's assertion of injury falls in the bucket of the abstract setback and doesn't come close to the kind of demonstrable harm that was at issue in Havens.
General, I'm sorry.
I'm done.
Okay. That's a helpful clarification. I'd like a similar clarification. Thank you. With respect to individuals, I've heard and listened to your argument and read the briefs, and I think I understand it. But how does it fit in your mind with offended observers standing under the Establishment Clause, or some injuries about I access a park and I like to look at it in a certain way, and those kinds of injuries that the court has sometimes recognized and other times cast doubt on?
So it's true. I think that there are different strands of this court's precedent, and I would put the Establishment Clause precedent and First Amendment precedent generally in its own bucket because the court has sometimes recognized different theories in the First Amendment context.
Back on that a little bit, because standing is standing. It's Article 3,
yes,
right, that we're interpreting here. And so I think we've got to find some way to stitch it all together, and I'm looking for guidance from you.
So I think the way to approach this is to, if you're going to recognize some kind of offense or distress type of injury, that to recognize that there
Should
has
we?
Well,
I guess as a preliminary.
no, I mean, I represent the government, so I think that kind of theory of injury would likely go far too much in the direction of allowing Article 3 courts to weigh in based on generalized grievances. But I guess what I would say is to distinguish the cases where this court has sometimes found that type of injury cognizable. Generally, it's in a situation where there is a kind of direct governmental action producing that type of injury. And here, our argument is that the FDA's actions in approving mifepristone, specifically in 2016 and 2021, if you're looking at that, which was an incremental change, is so far upstream of the downstream assertion of harm or distress that the respondents are asserting that there is, just as a matter of law, an attenuated link here that cannot suffice for Article 3 jurisdiction.
Thank you.
Thank you, counsel. Justice Thomas, anything further? Justice Alito?
Oh, you say that the Fifth Circuit didn't give any reason to think that the 3 changes made in 2016 would be more dangerous in combination than they were individually. But isn't that obvious that 3 things that may be innocuous or not excessively dangerous, if engaged in by themselves, may become very dangerous when they're all done together? And why shouldn't the FDA have addressed that?
I think the only way that would be true would be if the 3 changes are interconnected and mutually reinforcing, guarding against the same kind of safety risk. So I agree that if there were a reason to think that the reason why mifepristone is safe up to 10 weeks gestation is because it's being prescribed by doctors instead of nurse practitioners, for example, then those changes would be interconnected because one change would effectively be the safety net for another. But there was nothing like that in this record. The studies that FDA examined instead demonstrated that these changes, and it was an exhaustive examination, were safe not because there were other different safeguards in place to guard against risks, but rather because if you go up to 10 weeks of gestation, there is no observable increase in serious adverse events, no matter who's prescribing. So in the absence of that kind of correlative effect of the changes, I don't think you can fault the agency for not giving even more explicit attention to this issue. And it did. It cited multiple studies that combined multiple changes precisely because the standard of care had evolved over the 15 years mifepristone had been approved, and many of the changes were already being deployed together safely.
Shouldn't the FDA have at least considered the application of 18 U.S.C. 1461?
So I think that the Comstock provisions don't fall within FDA's lane. FDA, under the FDCA, can only maintain restrictions under the REMS program if it's necessary to ensure safe use. In 2021, what FDA determined is you don't need in-person dispensing for safe use, so the FDCA did not independently require that REMS restriction, and in fact, it couldn't be imposed once FDA had made that determination. Now, that doesn't affect other sources of law. FDA was not affirmatively approving, mailing, in violation violation of Comstock, even if you interpreted it that way, and we don't think it means what respondents suggest it means. But at the very least, I don't think that it was FDA's responsibility to consider that, nor could it have permissibly considered that under the statute.
Well, it didn't say any of that. It didn't say anything about it. And this is a prominent provision. It's not some obscure subsection of a complicated, obscure law. They knew about it. Everybody in this field knew about it. Shouldn't they have at least addressed it? You have answers to the arguments that are made on the other side. Shouldn't the FDA have at least said we've considered those and provide some kind of an explanation?
Well, let me give two responses. One is that I don't think it would have even been permissible for FDA to consider maintaining this restriction because of Comstock. If you look at the relevant statutory section here, it's 355-1G4. This is reproduced at page 6A of the appendix to our brief. It's very clear that the only thing FDA can take into account for restrictions are safety and efficacy concerns in deciding whether to maintain a REMS program. But the other thing I would say, Justice Alito, is that the agency did have a memorandum on Comstock. It's at JA 535. That was the advice that FDA received from OLC conveying the interpretation of Comstock.
They got the advice from OLC, but it didn't refer to that, did it?
In the 2021 decision, no, but the REMS was then modified in 2023, and this was part of the administrative record for that.
Okay, one last question. The plaintiffs say that the studies that the FDA relied on for the 2021 amendment say that mail order mifepristone suggests more frequent trips to the emergency room. Now, this is what I see as the FDA's response to that. Quote, although the literature suggests there may be more frequent emergency room care visits related to the use of mifepristone when dispensed by mail from the clinic, there are no apparent increases in other serious adverse events related to mifepristone use. Does that really count as a reasoned explanation to the suggestion that the data shows there are going to be more emergency room visits? This is the increase in emergency room visits is just of no consequence. It doesn't even merit some comment.
That is a reasoned explanation. What FDA was observing in that passage is that although it acknowledged the fact that some of the studies reported additional emergency room visits, that didn't equate to additional serious adverse events. And in fact, one of the studies, half of the women who went to the emergency room didn't get any treatment at all. Many women might go because they're experiencing heavy bleeding, which mimics a miscarriage, and they might just need to know whether or not they're having a complication. But in that kind of circumstance, the woman is not having a serious adverse event from mifepristone, and so it doesn't call into question the safety determinations regarding the drug. And at the end of the day, FDA carefully parsed those studies. It made specific determinations about the results to be gleaned with respect to safety and efficacy. It fully explained its decision making, and I think it falls well within the zone of reasonableness under arbitrary and capricious review.
All right, thank you. Justice Sotomayor?
On that last question, because that did trouble me, but the reality is, even if there is some increase in emergency room visits, the question of when that rises to a sufficient safety risk is up to the FDA, correct?
That's right. And, FDA acknowledged it, so it's not like it overlooked this aspect of the studies. I also want to emphasize, Justice Sotomayor, that the studies were far from the only evidence FDA consulted. At the time it acted in 2021, it had real-world experience during the COVID-19 pandemic, a period of time when the in-person dispensing requirement was not enforced, and FDA started by looking at, as a comparative analysis, the two periods of time when you had in-person dispensing and when you didn't, and saw that there was no relevant increase in serious adverse events or difference between those two time frames. So that further supported the safety conclusion.
The problem with all drugs is there are complications in virtually all of them.
Yes,
and
virtually
at
all.
what level the cost-benefit analysis tells you to stop prescribing something is a very difficult question, isn't it?
And that's a question that Congress has entrusted to FDA.
But putting that aside, here, whatever the statistical increase was, FDA determined under the REMS standard that it wasn't sufficient to create a risk that counterbalanced the need for access, correct?
Correct, because FDA is instructed to take into account burdens on the healthcare delivery system as well, and it looked at a variety of sources of data to conclude that on balance, the burdens were suggested that it was not necessary to keep this restriction in place to ensure safe use.
Thank you.
Justice Kagan?
General, if I could take you back to the discussion that you were having with Justice Barrett about the conscience objection. and just ask you, I'm sure that you've read the declarations carefully, and I'm sure Ms. Hawley will have things to say about this too. But as you read those declarations, what is the conscience objection? What are the doctors objecting to exactly?
I think the declarations are specific on this point. There are only 7 doctors who regularly practice and submitted evidence, and the declarations are relatively short. This is at JA 150 to 200. I encourage reading them because there are only 2 doctors out of the 7 who even provide any information about their specific conscience objections.
Those 2 are who?
Those are Dr. Skop and Dr. Francis. The relevant language for
The other 5 don't refer to conscience objections.
They don't refer to their own conscience objections or provide any specific detail about exactly what care would violate their conscience. Dr. Francis is at JA 155. Dr. Skop is at JA 167. Both describe the injury in the same terms. They object to ending the life of a human being in the womb and fear that they might have to complete an abortion for a woman who has an ongoing pregnancy.
So as you understand those declarations, they do not object to providing whatever care is necessary to a person who may have complications from taking mifepristone. In other words, for example, suppose somebody has bled significantly, needs a transfusion, or any of a number of other things that might happen. As you understand the declarations, there's not an objection to that.
I think that the fairest reading of the declarations is they are not objecting to that. Now, I acknowledge that respondents in their red brief have suggested there's a broader conscience injury in play here and that there might be other doctors who have a broader concern about providing any care. Even if that broader conscience injury had been in this declaration, we think still as a matter of law, they could not demonstrate that they have a non-speculative injury, in part because of all of the upstream things that would have to happen in terms of a woman having the serious event, going to these specific doctors, but also the fact that federal conscience protections are specifically designed to deal with this issue, and they would cover the range of conscience objections that exist in this context.
Right. There are obviously conscience objections of all kinds. I was just asking about the particular declarations of these particular members of the
Yes,
organization.
and I think on these declarations, they have not asserted a broader injury, but even if they could conceivably come forward with other doctors or try to adjust their declarations in some way, still that would not suffice.
Okay. Can I just ask a quick question about the merits? You open your brief with a somewhat arresting statement, but it starts with "to the government's knowledge," and this was written a few months ago, and since then I'm sure that you've had lots of time to think about this case and to get all background information on it. So I'll just read you this sentence and ask you whether it's still true to the government's knowledge. To the government's knowledge, this case marks the first time, and I'm going to say, is it the first time? Is it the only time? Any court has restricted access to an FDA-approved drug by second-guessing FDA's expert judgment about the conditions required to assure that drug's safe use. Is it still the only time?
That is still, to our knowledge, the only time a court has done that. We have seen a disturbing trend of courts sometimes also overriding FDA's judgment to try to grant greater access to drugs when that overrides FDA's expert judgment about what's necessary to ensure safe use. And no matter which direction you come at it from, we, on behalf of FDA, think that courts have no business making those judgments in the absence of the kind of arbitrary and capricious error that would satisfy the APA.
Thank you.
Justice Gorsuch? Justice Kavanaugh?
Just to confirm on the standing issue, under federal law, no doctors can be forced against their consciences to perform or assist in an abortion, correct?
Yes, we think that federal conscience protections provide broad coverage here. Just to be super precise, there are some triggering requirements of receiving federal funding and so forth. We've cited the relevant provisions at page 5 of our reply brief. The church amendments have the most comprehensive protection here, and we think that those amendments guard against the kind of injury that respondents are asserting. There are also state law protections that often apply in this context.
Thank you.
Justice Barrett?
Would that be true even if the declarations were interpreted as respondents do, to say that they regard any participation, even transfusions or D&Cs, after the abortion is otherwise complete because tissue needs to be removed?
Yes, I think that would be true. So the most relevant church amendment provision is 42 U.S.C. 300A-7D. And its language says that a doctor shall not be required to perform or assist in any part of the healthcare program that would violate the doctor's religious or moral beliefs. So it's tied to the nature of the doctor's beliefs rather than particular procedures.
And one other question, and this goes to the merits. As I understand it, the serious adverse consequences that have to be reported or that FDA considers risks are death and transfusion, but not say, I mean, it seems to me, and I think the data bears this out, that the elimination of the in-person dispensing requirement or, the in-person visit at the outset would lead to mistakes in gestational aging, which could increase the need for a DNC or the amount of bleeding, et cetera. But that does not count, correct, as an adverse event?
So I want to be careful because there's a list of serious adverse events, and I'm not sure that I have all of them down to be able to recite them to you, although they're in the record. But I do think the premise of the question is wrong, this idea that the change to in-person dispensing would necessarily increase the risk of those events. That was not reflected in the data that FDA consulted, and I would point you to JA 383 to 384 in particular, where FDA explained that even in person, you're not necessarily getting an ultrasound. That's never been required. And so the relevant question might be, is your provider going to ask you a series of screening questions, like when was your last menstrual period, in person or via telemedicine? And there's no evident reason why that difference would actually lead to different safety outcomes.
So there was not even I thought that there was a small percentage increase in the tracking. I'm wrong about that, which I may well be. You know the JA way better than I do.
Yeah, so I think that with respect to the ER visits, there was some evidence that there were increased ER visits, although as I explained to Justice Alito, that wasn't actually correlated with an increase in serious adverse events. I don't want to represent all of the different findings of the different studies because they varied a little bit, but FDA's ultimate conclusion was that mifepristone could safely be dispensed without in-person visits. It had voluminous evidence, I think, to support that conclusion in 2021, and there's been no contrary evidence that's been introduced.
So there was no requirement of either an ultrasound or detecting a fetal heartbeat or anything like that, even before the doctor could just go based on the woman's recounting when her last menstrual period was.
That's right, and that dates all the way back to the initial approval of this drug in 2000. It has never been a required condition of use to have an ultrasound. FDA has always left that up to medical judgment. Now, it's of course necessary for providers to be able to diagnose ectopic pregnancy and to date gestational age. That remains true under the REMS now. Prescribers still have to have that capability, and they have to deploy whatever mechanisms they believe would accurately allow them to identify contraindications for use of mifepristone. But it's wrong to suggest that if the court reverses 2021 changes, then every woman's going to get an ultrasound. That's never been the state of play in how this drug has been administered.
How, even under the pre-2021 REMS, was it possible to detect an ectopic pregnancy without an ultrasound unless the woman was presenting with pain?
So there's a set of screening questions that are often deployed. You can ask things like, do you have unilateral pelvic pain? Did you become pregnant while you had an IUD in or after a tubal ligation? Are you experiencing unusual bleeding? You could ask whether the woman has had a prior ectopic pregnancy. And if the woman has those kinds of risk factors, then imaging may be necessary. But that remains true under the 2021 REMS as well. The prescriber has to be confident that it has excluded those kinds of conditions before prescribing this drug. And the standard of care around the world, most medication abortion occurs without an ultrasound. Thanks.
Justice Jackson?
Good morning, General. So I'm worried that there is a significant mismatch in this case between the claimed injury and the remedy that's being sought, and that might or should matter for standing purposes. I don't know that our doctrines sort of capture this, but I guess I see it that the injuries that the respondents allege, as you've articulated them, are a conscience injury, that they are being forced to participate in a medical procedure that they object to. And so the obvious common sense remedy would be to provide them with an exemption, that they don't have to participate in this procedure. And you say, and you've said here several times, that federal law already gives them that. So I guess then what they're asking for in this lawsuit is more than that. They're saying because we object to having to be forced to participate in this procedure, we're seeking an order preventing anyone from having access to these drugs at all. And I guess I'm just trying to understand how they could possibly be entitled to that given the injury that they have alleged.
I agree, Justice Jackson, and I do think it's relevant to standing. There's a profound mismatch here between the claimed injury and the remedy they were seeking. And, you can almost think of this as a type of zone of interest kind of analysis. If the doctors have a conscience injury, there's a specific statute designed to deal with it, to specifically tailor-made guard against the risk of that injury occurring. And instead, they're reaching out and seeking to invoke rights under a different statute, the FDCA, that doesn't regulate them at all, that doesn't make them do or not do anything. And the relief that they're seeking would dramatically alter the approved conditions of use for mifepristone and affect women all around the nation simply because of this conscience injury that's already directly addressed by other protections
Right, and
of federal law.
if it wasn't addressed, then we would see this lawsuit, and the remedy would be to exempt them, right?
Yes. I think that one of the hard things about trying to tailor relief here is that they're asserting such a diffuse theory of injury that it's almost as though the only option was to grant a nationwide remedy of the kind the lower courts issued, and that runs counter to ordinary Article III principles of party-specific relief. But I just think it shows that there's something wrong with the theory of injury in the first place because it's so attenuated and because they claim they would need so much relief all over the country.
Let me ask you another question. In addition to the challenges that we have here, the respondents below challenged the FDA's initial decision to approve mifepristone in the year 2000. Of course, that occurred a very long time ago. The Fifth Circuit found that challenge wasn't timely because of the statute of limitations. As you're aware, in the context of another case we heard this term, the court is currently considering the statute of limitations issue. So setting aside standing, have you thought about how a ruling from this court on the statute of limitations in either direction might impact what happens in these kinds of cases with these kinds of challenges?
Yes, I think that it just reflects the stakes of the corner post case and provides a vivid example of the way that it might be possible if this court were to approve the request for a broader theory of the statute of limitations in that case, the way it could open the door to plaintiffs coming in and saying, well, I only became a doctor later, or I only started working in an emergency room later, and would try to unsettle longstanding agency actions that maybe occurred decades previously. I do want to say that I understand the corner post petitioner to have suggested maybe there would be equitable defenses that the government could raise in those kinds of cases. We would certainly want to raise that type of defense with respect to the approval of mifepristone, which I think has generated tremendous reliance interests and proven to be safe and effective over decades of use.
Thank you.
Thank you, counsel. Ms. Ellsworth?
Mr. Chief Justice, and may it please the court,